So I will start off with some very important questions under the background part 1 of my paper, which is under international criminal law. And some of the very important questions that I'm going to pose and show online. Okay. This. Okay, so some of these questions will be answered very shortly. And the first question being, these are the series of questions related. So what is the criminally accurate version of Elon Musk's Neuralink? So I will explain shortly using some samples. What is the legal meaning of scalable cortical computation? What is the pseudocode of algorithmic kernel or neurosynaptic core? What did he propose in the criminally false version of Neuralink in his medical journal? What is graphene net of field programmable gate array, or FPGA for short? And what is the criminal intent and the criminal act in being a 5.6G test site predator of 100+ nations? So I have many documented materials explaining in detail how this event-based implementation works, but this is just the introduction and the beginning part of explaining and unwrapping this entire segment on how the neuromorphic system, Neuralink 5.6G, and the neural grid population works. So this is just the beginning segment. So the legal meaning of Event 201 in event-based computation can be simply summarized as follows, that it comprises of a neurosynaptic kernel core architecture, and I divided it very simply into a few parts. The first is event-based communication, which is labeled as axons. So this synaptic neuromorphic system is modeled after the human brain. So that is why you see the word axons there. And it thread updates or assign neurons based on incoming synaptic spike events. So the individual neuronal firing will be captured whenever there is an incoming synaptic spike events. And there is a computation logic which states that if the neuron exceeds a certain program threshold, in other words, if it spikes, then it will transmit this spike event to a targeted synapse memory within the threads, and each synaptic spike event is replicated and sent to all target synapses and stored in the memory inside the threads hosting the targeted neurons. The event-based computation of the neurons is within a discrete time step of a neural simulation of a supercomputer simulator called Compass. So this is what it looks like. Okay, so it is very clear here that this is a legal exhibit of a pseudocode of algorithmic kernel of a neurosynaptic core. And you can see very clearly here that this is the legal evidence of a criminal blueprint of a pseudocode of algorithmic kernel neurosynaptic core. And you can see that it states very blatantly in black and white on line 5 that for synapse event targeting neuron synapse, you compute the neuron membrane potential and update the neuron by synapse event weight. So this is the exact code, algorithmic code, and it states very clearly here. The rest of the computation logic I will explain based on the published journals in the other segment of this paper. So this campus that is mentioned earlier on is actually a cortical simulator. It's a kernel software that runs on the BlueGene Q software program. I think it's available from IBM, which is linked to another source. And it's fabricated in Samsung, which actually means 3 stars if you translate it accurately into glyph translation. It's a 28 nanometer process technology with 5.4 billion transistors in a 4.3 cm square with on-chip network of 4,096 neurosynaptic cores that totaling 1 million neurons and 256 million synapses. And I will also be explaining the word kernel in an alternative product brand under Huawei section. So my paper is going to be very comprehensive. It covers all product ranges from China, from Huawei, Oppo to Korea, like Samsung, IBM, Intel products, Apple. So this is just the beginning introduction. So just to backtrack, what exactly happened? We can look at the US Southern District Court of New York judgment. And the case name is called the United States District Court for Southern District of New York. First Look Institute Incorporated versus National Institute of Health in the year 2021. And there are some legal questions under the Freedom of Information Act holding the power to account. First of all, this First Look Institute Incorporated has a paper called The Intercept. It is an award-winning, nationally recognized news organization with a reputation for holding power to account. And they brought an action for injunctive relief, seeking release of agency records from the National Institute of Health, NIH, under the American Freedom of Information Act, FOIA. Which focuses on the citizens' right to be informed about what the government is up to by fostering the release of official information that sheds light on an agency's performance of its statutory duties. And also in citing the Department of Justice versus Reporters Committee for Freedom of the Press, disclosure, not secrecy, is the dominant objective of FOIA. The Department of Interior, citing the Department of Interior versus Kalama Water Users Protective Association. The First Amendment's guarantee of the freedom of the press is to enable journalists to perform an essential role in our democracy, to bear the secrets of government and to inform the people, citing New York Times Company versus the United States. So this case is about Dr. Peter Daszak, his conflicting roles as being the sole US scientist on the WHO investigating the virus origin, yet at the same time he took a substantial amount of funds under the pretext of research grants to allegedly manufacture the study and I will be explaining in my paper itself a re-examination of the 3 sets of journals that is associated to his name and to the Wuhan Institute of Virology, and which engaged in controversial gain-of-function experiments. So what you see here on the screen are some of the substantial amounts of grants that he obtained to invest in this lab experimentation, and the lab reports clearly showed that there was infection and reinfection and successful infection, which is all documented very clearly inside my paper. Okay, so and just before I end this test video, I will just touch on some matters concerning the American telecommunications law and the European letter, and I also actually wanted to cover several other zones in the world. For example, the China batch. There was actually a very independent China-Yuan scientific analysis that deciphers in his academic opinion that it was military genetic engineering, and he managed to produce a lab report, and it's also detailed in my paper. So let me just touch on the American telecommunications law and the European letter. So I took out some very important case law, and I will just very briefly run through it in this test run of my video on my paper. So in the first case, that you see here is the case in Washington, D.C. Supreme Court. And it is entitled the United States Court of Appeals, District of Columbia Environmental Health Trust versus FCC, short for the Federal Communications Commission. It was decided on the 13th of August in 2021, and it covers T-Mobile USA, Dutch Telecom Europe, and I also have a very special write-up on these people that were called to the court. These Stars Technology Company, brand names and the background, the timeline. So I will be covering that in my paper, and if I have time, then the video presentation as well. So in this case, Environmental Health Trust, or EHT for short, versus the FCC, which is the Federal Communications Commission, they deliberated the circuit judge deliberated on whether the devices that transmit radio waves and microwaves, including cell phones and electrical devices such as radio, TV, collectively known as radio frequency, are sufficiently damaging to health, and whether there was environmental harm and long-term exposure to radio frequency radiation due to either pulsation or modulation. So in this particular case itself, it is decided that the radio frequency radiation is not ionizing enough. It's insufficiently enough to strip electrons from atoms. And so this is the loophole of the case on the CO-VAX, which is actually a chip, and it's a circuitry. And because this is just the beginning part of my paper, I haven't exactly shown and dissect the entire circuitry involved inside the CO-VAX injectables. And so this is the premise of the entire paper, and it goes beyond that. It goes beyond the circuitry itself. What the perpetrators are attempting to achieve. What are some of the other crimes under space law, pharmaceutical law, medicrime law, biomedicine law, human rights law, that this entire CO-VAX injectables entails. So there is inadequate legal case material. So this paper itself will have already covered the criminal mode of operation, and the evidence have already shown that there is intentional organ damage in neurological, reproductive, blood clot, HIV envelope, and the transmitters that are inside the CO-VAX circuitry, which is micro-constructed by microbots, remotely programmable by Wi-Fi transmissions. So a key point to note, considering that there is a very huge gap between and loophole in using this case law, which is inadequate to cover or even touch on the case on the circuitry, transmitters, electronic transmitters, connection to the frequency waves and the satellite transmission. What we can find useful in this case is that in the EHT versus FCC 2001, the Commission in 1996, under NEPA, promulgated guidelines for the radio frequency radiation exposure in excess of limits set as noted in the Cellular Phone Task Force versus FCC in the Second Circuit in 2000, was actually issued by three major parties, the first being the American National Standards Institute Committee. The second is the National Council on Radiation Protection and Measurements, and the third being the Institute of Electrical and Electronic Engineers, or the IEEE for short. So this here itself is the obvious legal loophole, because IEEE is precisely the publisher of and the conference organizer of the so-called synapse killers, meaning it's the transmitters inside the CO-VAX that could have caused the reception, the transmission of frequency waves that in turn led to organ damage and death tolls, and which is also directly transmitted the death statistics sensed from the stoppage of heart beating directly wirelessly to online statistics collection platforms, like, for example, the World Tourism Organization. They have a very comprehensive deaf statistics collection section, and so it is all very possible that they could have just directly transmitted the death of the corpse, stoppage of heartbeat, and neuronal functions directly into an electronic database wirelessly, since they have already been microchipped. So this is the first legal loophole, that IEEE is the publisher and the conference organizer, and yet is also one of the guidelines regulators commissioned in the EHT versus FCC case in 2021. So this paper will more than adequately address these legal omissions that is severely lacking in all the cases worldwide. And so this paper will focus on some of these key matters. For example, the issue of microconstruction from in-brain chipping introduced by the so-called Big Pharma, which namely is graphene oxide, silicon, and silicon oxide. So this paper will explain by gathering the lab reports that is very clearly evidenced in the photographic, microscopic from the Australian batch, the Spanish batch, the Brazilian, South American batch, the American batch, the China batches of COVAX injectables. And the purpose is to ionize the membrane potentials followed by neuromodulation from a remote computer for payload release. And hypothetically, but practically speaking, it is capable of releasing not just a virus, according to the IBM chip discussed under the drug tailor in my pharmaceutical law section. They can also have a lethal concoction of other materials like bacteria and eggs. And the kill switch is satellite linked to cell towers against population A to Z, and which is why it is called neurogrid population synapse. And I have a diagram to explain that in detail later on. And it can double up as a transmitter chain reaction, theoretically speaking, which is why it is called kill switch chain reaction. So this IEEE literature actually very extensively explained with computation logic, which I will also explain how this works. This Neuralink network and neuromorphic system, and this neural grid of population A to Z works. Okay, so let me just see if I should just touch on the second case, which is the California Court of Northern District judgment entitled T-Mobile West LLC versus the City and County of San Francisco. So some of the key bulk of this case just focuses on so that there is a few key points, but the first being that this particular case made the distinction that the denial of a franchise is different from the denial of a permit, because as we know now that the cell towers, they are trying to fight permit by permit. And so what happens is that the FCC is actually came up with a subsequent idea to stipulate some sort of advance permitted regulation without having to go permit by permit. So we will look at that later, but let me just look at some of the other relevant and important parts. So yeah, there are some very important points made in this case. T-Mobile versus San Francisco. They determine about the scope of permissible regulation. And citing the case of Southern California Edison Company versus PV in 2003, and citing the Greyhound Lines Incorporated versus Public Utilities in 1968. It explains that the state constitution vests principal regulatory authority over utilities, but carves out an ongoing region of municipal control. Firstly, a company that intends to build must obtain a certificate of public necessity, but it alone will not suffice. The utility is still subject to local control in carrying out the construction. Secondly, the PUC regulation of the utilities' relations with its customers are forbidden from yielding to the PUC their police powers to protect the public from the adverse impacts of utilities operations. And thirdly, the PUC's default policy is one of deference to municipalities. In the 1996 opinion adopting the general order governing wireless facility construction, the PUC states that the general order recognizes that the primary authority regarding cell siting issues should continue to be deferred to local authorities, intervening only when a utility contends that local actions impede statewide goals, citing resitting and environmental review of cellular, mobile, radio, telephone utility facilities, explaining that the order itself acknowledges that local citizens and local government, meaning the honors section of the military arm, since broadly speaking, as you can see very soon in my paper, that we are dealing with broadband lock-on aircrafts, seacrafts, bodily cells by satellite owners or satellite renters, which are the outer space perpetrators unbeknownst to the public. So the point is, non-corrupt local citizens are in a much better position to measure local impact, being the legal rationale behind why it is still vested in municipal control, local authorities, and local citizens. So then I will, in my paper, I have photographs going way back when the SoftBank founder Masayoshi Son and Sharp, they were together. So it goes a long way back. Right, and he approached Microsoft Gates. So they had a celebration dinner for Rocket Satoshi. So it goes all the way back. All right, and be also looking at some other key figures like Masayoshi Son meeting was recommended, picked by his magazine editor, so on and so forth. And because Gates was looking and commenting that every article was worth reading. And then through that, he met the Alibaba Group, which is Jack Ma, and also he has this Ant group featured in the FinTech Fest of Microsoft Bill Gates, and is actually short for antenna. And I will be explaining in my paper how these antennas work, short form N1, N2, N3 in a triangular, and how is it connected to the satellite. So, right, and you can see them when they're young, and also being born of a younger generation. I will also be interested to be looking at some of the latest inventions. So I've been busy working on all the technical details, but one of the other areas that I've yet to have time to look at is the NVIDIA chip. So that would be very interesting to look at. Right, and you can see that they also met UT Starcom with Masayoshi-san. So these are some of the graduates from California, I believe, that started the UN, UT Starcom, not UN. Right, so I'll be looking at this very interesting new AI chip. Izanagi in collaboration with the ARM chip design. So the next case is T-Mobile West versus the City and County of San Francisco in 2021. So this is a different year. And it concerns the parameters of the Spectrum Act in the matter of acceleration of broadband deployment by improving wireless facility seating policies. So the bulk of the case is there's some issues like anti-commandeering doctrine. So the defendants argue that the Spectrum Act violates this doctrine, that the Constitution confers upon the Congress power to regulate individuals and not states. So the defendant assert that the Spectrum Act does not create a duty for the local government to affirmatively issue permits, because the anti-commandeering doctrine reflects the Constitution's decision to withhold from Congress the power to issue orders directly to the states, citing Murphy versus National College Athlete. And the federal government may not compel states to implement by legislation or executive action federal regulatory programs, citing United States versus California in the year 2019. The defendants argued, therefore, that the Spectrum Act does not impose affirmative obligations to issue permits for T-Mobile applications. So I wrote down some of my legal notes and explanations concerning this Spectrum Act, the legal aspects and the technical meaning of spectrum in context that can connect wirelessly to the transmitters inside the COVAX injectables circuitry. So I went on to, you can see listed here the fourth item, Federal Communications or the Commission acceleration of broadband deployment by improving wireless facility seating policies, published by the Federal Register in Washington, D.C. on the 8th of January 2015. And I went to research on the document, and I wrote quite a substantial amount in proportion to the entire paper that I noted some of the very important points. So it's about like 3 pages, but I will just briefly touch on them in my legal opinion. First of all, that we all know that it is an agency, and so legally speaking, an agency to begin with has no legislative or executive power. They are not voted in. Nobody has any say. Nobody permitted it to have any sort of power. It has no power. So it does not have legislative nor executive state, and certainly since it has no power by itself, it cannot have any power over any state in the world. And also we know that under international law that self-titled gov is an advertisement or a sales tagline. It is irrelevant if a person who titles himself in a like governmental fashion or name himself as a official, it will be irrelevant under international law if his intent is to commit a crime. For example, murder, theft, even if he calls himself the government. So it is irrelevant. Whatever title that a person has, whatever designation a person has, it is already clearly stated as law, and it has already been clearly practiced as law and under international law, in particular, that a self-titled person is irrelevant when he has already committed a crime, for example, murder or theft. And under international law, it will be in the context of genocide, systematic, widespread crime against humanity, war crime, which is actually my personal way of explaining it, is that it is not war, actually. It is actually murder. War crime is murder of both armies and civilian populations. So it is not war. It is just murder of armies, which is exactly what is happening worldwide. Going way back to Rajaratnam and the +3 plot, the Eur Swiss, Synapse currencies. I made a distinction between the criminally accurate version with all the criminal technicalities included in my paper, and also the false version, which is the computer, which is adjustable. They can just press a button and make the numbers go up and down. So it is just controlled by a set of computers, controllers, and the processors. So that will be covered thoroughly in the other sections on my Computer Yuan and my Computer Yuan. And my Computer Yen, part of the +3 plot in association with the Rajaratnam. And also I cover the Nordic and the criminally accurate version is the Synapse version, the Synapse lock on and the aircraft's lock on, and criminally evasive version, which is targeting all the central banks, which is called like the Computer Nordic or the Computer Bank of England, which they call it digital pounds, right? But it's actually just a set of computers. So the Computer Bank of England, the computer bank, the computer dollar, which I cover very extensively, including the EMV, the merchants, merchant cards, and also I cover the central bank of the computer bank. I wouldn't call it the central bank. I would only call it the Computer Bank of Russia, because it is just a set of computers, and it is an online website which could have been accessible or designed from anywhere in the world. So I will only call it Computer Bank of Russia. And also I do a comparative explanation of how it works for both banks. And also I included the explanations from various commercial banks like JP Morgan, some very interesting input from JP Morgan. So let me just go back to this to finish up this part about the acceleration of broadband deployment. So the intelligent public already knows that the term deploy, it's a military term. And in this case, it is noted that the Chief Justice and the panel of judges, they had to make regular express references to the preserved beauty of California state. In the case, because in this document, Acceleration of Broadband, it is actually placed under the National Environment Policy Act of 1969, NEPA, which is one of the three parties involved in promulgating the guidelines, including the IEEE. And also under the National Historic Preservation Act of 1966, NHPA, with emphasis on accommodating new wireless technologies that use smaller compact antenna or distributed antenna system, DAS for short, or small cells, radio equipment, and broadband service deployed on utility poles, rooftops, and inside buildings. So even the words deploy and deployment is openly used in its title, a word reserved only in the military context. In other words, it has nothing to do with environmental aesthetics and historical preservation at all. But the judges, the Chief Justice, they had to make reference because of the categorization. And in my opinion, justice calls for, in this case, combating for the citizens' lives, their livelihood, the storage of their monies. So they were decreeing justice on behalf of the Californians against perpetrators that were deploying weapons technology due to the commission appointing the review process in this acceleration of broadband deployment. It also states that the commission's goal has always been geared towards the deployment of macro cells on existing towers and tall structures. So I've already mentioned that placing this deployment under the National Environment Policy Act and the National Historic Preservation Act, the aesthetic beauty, has seriously sidetracked or effectively cornered and erroneously could have forced the justice to focus on the wrong elements, to address the wrong and completely irrelevant issues, which will all be adequately addressed in criminal technical terms and legal terms, and the specific laws, which I made very simple for anyone to understand, and to see very clearly what are the different legal crimes committed, the legal issues, and placed under which category of law that have been contravened. and also what this whole circuitry, how it works. So also I've noted that in this deployment document by the FCC, it speaks of a wireless telecommunications bureau using the words final programmatic. And we already know that this word programmatic also appears in the multi-phase programmatic approach in the WB document, which I will also explain in criminal technical terms or military terms. And also I will explain legally assess the blurry lines between using the word military, like agency or DARPA, and what it really means to be part of the military, and when it crossed the line to being murder. There is a difference between murder and how the lines were blurred intentionally. So anyway, in this document, there is the words final programmatic environmental assessment for the antenna structure registration program. Concerning the installations, I just want to touch on some other key points in this document, that when it says deployment of antenna inside the building is strongly preferable than its exterior. Now, obviously, there's something really not quite right about this, because it states very clearly in the document, I repeat, deploying the antenna inside a building is strongly preferable than its exterior. And then it goes on to explain the reason for it. It is because that the building's exterior structure would serve as a buffer. Now, a buffer against an explosion from microwave or high frequency waves. So it can refer to a repeated incident of trapped inhabitants, for example, office, residential, government buildings, aerial plants, airports, towers, power units, wireless telecommunication facilities. So for this kind of installation, they send and receive radio frequency signals in a omnidirectional or parabolic direction, and also subject to radio frequency and sensors, a range of sensors. So the idea is that in the event that the broadband frequencies exceeds its legal limits, it may explode. It can exceed its legal limits if it's remotely programmed by DEW exotic tech computer, a set of computers in the ground station. So if it were to explode, this can thus explain the word buffer, and thus explain why the agency thinks that it's preferable that the deployment of the antenna is placed inside the building, because it will buffer in the event of an explosion from radio frequency waves. Also, there is another section on the European Telecommunications letter. I will stop here. My paper is packed full of academic materials, legal judgments, case law, the law on the matters, and criminal technical explanations of the IBM Intel DARPA type chip circuitry with real life evidence collected from the Americas, including North and South America, Australia, the China batch, the Spanish batch, the European lab reports. And also I will be covering as mentioned earlier on, the computer banks, central banks, the commercial banks, the criminally accurate version and inaccurate version, explaining in detail. So we'll be covering a lot of countries in the world and many zones, including Japan, China, and Korea. So it is a very interesting paper, and I hope once everything is ready, the readers will find it very interesting and very useful document in explaining and understanding a lot of circuitry, satellite weapons, neuromorphic systems, and the telecommunications gadgets, and the various categories of law concerning this. And it will be made in a way that is very easy to understand. I've written it in a way that is very easy to understand, with diagrams attached as well, and also photographic evidence. So I thank you very much for your time, and I'll just end this test video run. Thank you.